Hi, this is Gary with DeWitt Law. Estate planning allows you to stay in control. Estate planning stops you from being a victim of circumstance, not be a victim of what is happening around you, not be a victim of time passing, accidents, medical incidents, and more. I wanted to give you information face to face, but not take up 45 minutes to an hour of your time. I want to take about 10 minutes to tell you what you need to know about estate planning. The only unfortunate thing is that I can't answer your questions interactively, but you can always call us at 479-717-6300 to ask your question. That's 479-717-6300. If you're watching this, we are offering free consultation. Go to dewitt.law/SA to set up your consult 24/7 or call 479-717-6300 to set up a time to come in and chat. Here is what you need to know about estate planning in 10 minutes, starting now. Many people start with estate planning and go straight to the complicated issues like trust and deed protection. Those are important issues, but they're not the foundation of a plan. You need to build a strong foundation first. The most important things you should have in place during your lifetime are the foundation. The foundation lets you take control of your financial, legal, healthcare, and personal future in general. The first step to building the foundation is picking the people you want to be in charge if you can't be in charge. For most people, this is their spouse followed by children. But it doesn't have to be your spouse or your children. If your spouse is unable to manage and your children are too immature, then you can pick a trusted friend or other family member. If I were in an accident, had a medical incident, illness, or were injured, my wife wouldn't be able to manage our assets without a durable power of attorney. She wouldn't be able to manage my accounts or our real estate. If she needed to sell the house or property just in my name, she wouldn't be able to sign for me. The first piece of the foundation, the footers, is the durable power of attorney for finances and legal matters. A financial power of attorney stops my wife from the need to go through the courts to get a guardianship for me and the courts overseeing our assets. It also allows her to manage my legal affairs and personal matters as needed. Second, we want to put backups to take our place as our agent for each other if the other is incapacitated. So, if my wife can't handle my affairs because we're in a mutual accident, or maybe she passes away before me, I want to make sure our oldest son can come in and play that role. For each of these positions, for agents of power of attorney, for executors for wills, we want to make sure we have a backup. The second foundational estate planning document is healthcare powers of attorney. It is extremely important you have healthcare powers of attorney in place. It is arguably the most important document you can have. It can be argued that it's more important than a financial power of attorney. A healthcare power of attorney is about making critical healthcare decisions for you, but only when you can't make healthcare decisions for yourself. So, when I'm incompetent or incapacitated and can't make healthcare decisions, who is the one person I want to appoint to make decisions for me? And I say one person for an important reason. I have multiple children with different strengths and beliefs. It may be hard for them to reach the same decision. They may argue over whether the decision is important or not, and I don't want to lay there suffering or not having a decision made that needs to be made in a snap, in the moment. It needs to be a quick decision because I didn't appoint one of them to round up the family, discuss, and make a snap decision. It may be the most important thing you do, setting up a healthcare power of attorney. You want to make sure it's well drafted in Arkansas and HIPAA compliant so medical records can be obtained. That is extremely important. A brother document to a healthcare power of attorney is a living will. We want those documents to talk and communicate with each other. A living will is also called a declaration of desire for a natural death. It's different than a do not resuscitate order. A do not resuscitate order is a document you make with your doctor. Maybe if you've been through a lot, resuscitated before, and you say no more. But if I have a heart attack right now, I ask that you revive me because I have kids to feed, I have work, and I want to continue. A living will is different than that. It's for that last day situation or your terminal. You're being maintained by artificial respiration, nutrition, and hydration. How do you want to be treated in that situation? Is it okay to let me go if the only medical procedures will prolong my suffering? I want to make sure I relieve the liability on the doctors, the hospital, my family, and my healthcare agent. It also allows me to incorporate religious preferences such as to be ministered to before I pass. And it allows me not to be stuck in limbo indefinitely. It allows me to take control. In estate planning, everything we're talking about allows you to stay in control and not be a victim of circumstance, to not be a victim of what is happening around you, not be a victim of time passing. Even if you're incapacitated or incompetent, you can appoint the person who's in charge of your finances and health care. And your voice can be in the room to decide that last moment if you're ever in the situation, if brain death has occurred and you're being kept alive by respirators. I want to say that it's okay to let me go, as I don't want my body to linger on and not suffer indefinitely. Only now are we ready to talk about wills and trust. At this point, we consider your probate avoidance plan. To know whether you should need a will or a trust, you need to have a basic inventory of your real estate and other property. Then you need to decide who gets what, when, how, and how much. You need to examine your family situation. Your children may have circumstances in their life that will decide if you need a will or a trust. First is a will. All plans include a will. Even if you have a trust, you will have a will. A will is a document that's biblical in age. A will allows you to choose your executor. You decide who's in charge of executing your will. You pick the person, making sure that the money and property that must change title is handled properly. Make sure that it's handled properly at the courthouse. That's the role of the executor. You want to have a backup in case the primary executor you appoint can't do the job for any reason. Also, a will allows you to appoint who gets money and property. You decide who's an heir of the estate, not a judge. You may want your spouse to get everything first, then your children. You may want to set aside some for the grandchildren. You may want to designate some to go to a trust, or you may want to set up a trust for college costs. You want to make sure that what should be a blessing doesn't become a curse by cursing a young person with too much money too soon. You may have seen that before, when a young person has too much too early before they have the advantage of life experience and education to guide them in using the money. Then we can start stacking on deed protection to protect your house against Medicaid recovery in case you need Medicaid for long-term care and Medicaid has to pay. We might want to look into a trust to put assets into. Trusts range from just probate avoidance to complete family protection. Some of the times you want a trust are when your children have problems that would be helped by not giving them a lump sum. Or perhaps your children don't get along and you want to sell everything and split the money. If you have a child with special needs, credit issues, addictions, a rocky marriage, and more, then a trust will protect them from themselves and outsiders. We might want to set up an irrevocable trust to protect money or family land that can't otherwise be protected from Medicaid recovery. That's a quick summary. We're here to help you. We offer consults by phone, in person, or via Zoom. I'm going to hand over the ability to set up the consult yourself. Just go to dewitt.law/SA. We're here to help. If you have questions, call 479-717-6300 or set up your free consult today.